Now, it is my very great pleasure to introduce our speaker for tonight. Gerald Shamash is the solicitor in our case, if I can put it like that, our case, Maria Nash's case, against Barnet Council. As you may know, we lost on a technicality and won on the substantive issue, and the appeal will be heard on the 15th of July at the High Court. So I'm inviting Gerald to come forward now, take over the microphone.
Can you hear me without? No. Okay, I'll try and sort of. Thank you very much indeed for inviting me this evening to speak to you. Sitting at the back, obviously, is Maria. I mean, one of the delights about the court case is, I don't know if you know, when you go to the High Court, the judges sit quite high. Yes. And in comes Maria in her wheelchair, and she's got this magnificent button. And the chair just goes, so you've got the actual perfect. So there she's looking the judge in the eye. The only thing is, Maria, is the Court of Appeal is even higher. I really have no idea how high your chair will go. But let me just warn you, the Supreme Court is actually on the same level. So there's no problem about that. You have no problem if you get that. First of all, thank you very much, as I said, for inviting me. This has been quite an extraordinary case in its own way, because it's actually opened the door to a lot of the problems of judicial review and the way that judicial review is handled by the courts. And we hope, ultimately, that the decision that we will get on the 16th, 17th, 15th, 16th, in a couple of weeks' time, in the Court of Appeal, will actually be for the benefit, not just of the people of Barnet, but I mean, Joseph quite rightly paid tribute to Maria, but it's a tribute to all the people in the Barnet Alliance of Public Services who put a tremendous amount of time and effort into this. And the team I was in, to use her here, I don't look like to see her, there may well be other people there, Mrs. Mustard, Mr. Angry, David Bishop, etc. You've all been incredible, and to have a team like that, I cannot, as a lawyer, you know, to have a group like that who are able to throw questions out and to think to come back quickly, and to have that such to have barristers and solicitors to turn around that information, really you cannot underestimate that. And it's a tribute to you that we've got this far. But it's also a tribute, and I do want to pay this thanks to, he's not here, is the junior barrister in this case called David Gerald, who personally picked this case up, and I can remember having an hour-and-a-half telephone conversation with him when I was having a break in Amsterdam, just going through what we were having to do to try and get this case launched. Now, as you may remember, this matter really sort of came to the fore in a substantive way towards the end of the 2012, when Barnet had a decision on the 6th of December about its final decision about outsourcing. We immediately brought a challenge, and I say immediately, and it's highly relevant to judicial review, is that we immediately brought a challenge, and within about 2 weeks, despite the Christmas, and this is David's Gallant's tribute to him, the work that was done during the Christmas break by all the lawyers involved, but the work that was done managed to get the proceedings launched within the time that it needed to be. Now, judicial review has very strict time limits, and it's relevant to where we are now, why we actually are finding ourselves in front of the Court of Appeal. You have 3 months in which to bring a case, and that's really from a decision. Now the issue is, what is this decision that you bring it from? Is it a contingent decision? Is it a provisional decision? Is it a final decision? And that is stuff that we're going to have to find out perhaps in a couple of weeks' time. But we acted pretty efficiently, I thought at the time, to get this launched. Now, what also played a really leading part, as you know, is the funding of a case like this. And it would have been pretty much impossible, I would have thought, for a group like Barnet Alliance to have actually funded this and to actually put somebody up as a notional plaintiff or claimant, if we hadn't been able to enlist somebody who was eligible for legal aid. But to get legal aid, as you probably know, certainly as it currently stands before the government changes the rules in relation to judicial review, But to actually get legal aid in that situation, you really have to get a merits test. You have to show right at the beginning that actually there's a case worth fighting. And that in itself, once you've got past that hurdle, then you kind of have confidence taken about the fact, well look, they're pretty mean, to put it mildly, those who may or may not have themselves been applied for legal aid, people have had it turned down. The criteria are very tight. Unfortunately, in the rear, very to the memory of Bugle, where the person put herself up to be the lead claimant, and that is what happened. We managed to get legal aid for what was known as a permission hearing. Now, judicial review works in this way. You actually have to have permission of the court to have a full judicial hearing. And we applied on paper in the normal way, which we made a paper application setting out the basis of what we thought there'd be lack of consultation, etc. I'll come to all that in a bit more detail in a minute. And what then happened is that Barnet, then we wrote what's known as a letter before action, setting out the case, why we thought that what Barnet was doing was wrong, and asking them, as the contracts had not been signed, not to sign the contract. Barnet came back, when they're due, their lawyer said, look, we won't sign the contract until the outcome of your hearing. And what then happened is that we decided to have what's known as a rolled-up hearing. Now that sounds a bit odd, but it's not particularly on the end of a cookery book, but actually having a sort of rolled-up hearing means that you have the hearing for the permission to have a judicial review and the substantive review itself. And that's in fact what did happen. And that took place before Mr. Justice Underhill, who has since actually himself been promoted to the Court of Appeal. And it was his judgment that we are now appealing against. Now, in relation to that, there were four main things that we were seeking to challenge. One was the failure of Barnet to consult. It's the maxim all of you put together is nothing without us, nothing about us without us, which is something that certainly Maria keeps dropping into me every time I see her. And she's absolutely right. We have no taxation without representation. Why should we have these major decisions taken without us being involved and being consulted in the way that we should be? The other one was the public sector equality duty, which is the position that comes when you have people who are in a particular characteristic, and there are potential discrimination issues in relation, for example, about sex, about race, about disability, about transgression, all the whole range of things. And that was one of our other planks of our application. And finally, there was the fiduciary duty, which was the kind of legitimate expectation as you, as a member of the electorate of Barnet, have expected your council, when you elect somebody, you expect them actually to fulfill. You have an elected council here, I can see today over there. You have an anticipation and a respect that he will actually listen, and I'm sure he does, because I've known Mr. Jack Cohen for a very, very long time. He will listen and he will take on board what is being said. And you have a legitimate expectation that your council and the council itself will actually listen to what's happened. And we maintain that they didn't, they breached that. At the hearing itself, what then happened is that we decided that the court was not, we went through the arguments that were submitted, and I don't want to get too legalistic about it because it gets rather boring and it's quite a long time reading. But there is a number of issues that I wanted to particularly highlight. One is the most important one, which is obviously the failure to consult, and the finding of the particular judge, which I think you may have seen, because on the notice of the meeting, there was one wonderful saying which I've temporarily lost, which was the position about Barnet's never intended to consult at all. And in fact, what happens is that there is a section of the Local Government Act, so section 3.2 of the Local Government Act 1999, and it says, a best value authority, which is what this one is, before the purpose of deciding how to fulfill the duties arising under the Act, which is about the improvement in the way that the functions are carried out, and having regard to the economy, diversity, best value issues, this is the crucial thing. Representatives are persons like this, for the purpose of deciding how to fulfill the duty arising under the section, the authority must consult, I repeat, must consult. And the people it must consult are representatives of persons liable to pay any tax, precept or levy or in respect of an authority, and the authority must consult them. Now, as you know, in relation to the actual judgment, the court found that Barnet did not consult, and in fact never intended to consult right from the beginning. That was our main plank. And the judgment came down, as you know, in favour. Now, the issue is here, of course, ultimately, as you know, is the issue of timing. Now, before I come to timing substantively, there was also the public sector equality duty. And there is a responsibility of the local authority when you have that duty imposed on you, i.e. because you've got to deal with people with diverse orientation, sex, race, and other disability, you have to do what's known as an equalities impact assessment. And this actually was carried out by Barnet in a kind of almost laughable way. And that I think, correct me if I'm wrong, there were about 580 people that were consulted in a rather oblique way. And there was a very, very poor response. And I've got the figures somewhere, I can't immediately lay my hand on them. But the court found, and that was, we decided not to proceed with that particular aspect of the play, because we didn't think in the end it was substantive. And the court decided too that actually this was not though Barnet had consulted, the onus on them wasn't as substantive as it was on the main issue of consultation related to the whole of the outsourcing issue. So, in terms of the public sector equality duty, that has now moved away, and we're not going to be dealing with it in the appeal in a couple of weeks' time. Now, the main thrust of this, and the main problem, is the question of delay. Now, I mentioned about 3 months. That is the crucial time. We were within time as we perceived it. We perceived time as running from the 6th of December, which is the decision to act, the final decision to outsource and give the contract to Capita. The judge found that he thought, his view was that this actually took place in 2011, when the contract was first mooted by the council and it was advertised. And you have to advertise this because it's under a public sector contract, has to be advertised in Europe with the European journals. And the view was taken that actually that was the time for when the consultation took place, which is 2011, which is, we were way out of time on that basis. The problem is if you make a decision to outsource, and then you know that there are statutory obligations on you from 2011 until the final time to consult, and you never consult, has time started then? Or has time started when you make the final decision? Now, there is a leading case on this, which is the Bugle case, which is decided by the House of Lords in Hammersmith and Fulham some time back. The point is, on our case, is that the judge should have followed that decision. And that decision was to set down, you actually appeal from the date of the final decision, not a contingent decision or provisional decision, but from the final decision. And that is actually what is going to be the essence of this appeal. Now, it's questionable then for the judges going to have to make a decision as to see when the breach of the consultation first occurred. In other words, when did they first breach their duty to consult? And if that's so, when does that time start? When was the final decision? And that, in a sense, is the core of our appeal. Now, the reason this is important is it doesn't just apply to this judicial review, it applies to all judicial reviews. Because if you are going to seek, whatever the challenge is, if you are going to seek judicial review, you've got to have a position from which to actually appeal. You can't appeal something that's a moving target. Because if you think as soon as somebody has an idea, it's a really good idea, let's do some outsourcing. Let's say another local authority, let's say Lewisham, say, randomly, and they decide tonight that they would actually like to outsource. Do you immediately judicial review? They will say, hang on, what are you doing here? This is premature. We haven't made a final decision. We're going to consult. We're waiting to do this. So we say, okay, go and consult. And they don't consult, we make representation to them, the videos are produced, all the things that were produced by Tessa, Barbara, and all the team, showed quite clearly that they didn't do so. So we contend that the final decision actually was December. And that is the decision that the Court of Appeal is going to have to grapple with. I'm pleased to say that legal aid, because they've seen the merits, the council has to do an opinion to the legal aid board to justify why we should appeal, and why we have good grounds to appeal. And they've supported this, much to the chagrin of Barnet, as you can imagine, because ultimately they are having to spend a lot of money fighting this. Fair enough, it is our money, ultimately the ratepayers' money. But in terms of that is peanuts, not even peanuts, smaller than peanuts, atoms, I would say, compared to the almost £1 billion contract for 10 to 15 years that is actually going to will all be lumbered with if in fact this does go through. So the issue is a really important one. I would have thought, and there's a reasonable chance that if we are successful, the Barnet itself might appeal to the Supreme Court. As for ourselves, I don't know, we will have to wait and see. And there's a problem with that, because if you get refused with permission twice, because that's essentially what is happening, we are appealing again to the court for permission for leave to judicial review. And if they refuse again, it's much more difficult to go to the Supreme Court thereafter. So hopefully we'll be successful. Hopefully that the judge who decided to take this call, take this case, is the second most senior judge in the country, the Master of the Rolls, who has decided that this is a case he would like to hear. It means that we've got a senior court, so they will not be frightened of making a decision. It also makes it slightly more difficult if it goes against us to take it on further, but we can worry about that further down the road. So, all being well, I hope we'll see many of you at the Court of Appeal in a couple of weeks' time. I'm sure I'll see all my friends in the team. And we will see, hopefully, that Nigel Gifford, who's our Queen's Counsel, I'm sure will give an extremely good account of themselves. One of the things I should say was that Barnet have agreed, again, not to sign the contract, but we wrote a fairly strong letter setting out the position to them. And they were quite relaxed about this, up until the point they realised that their QC, who used in the Court of Justice and in the High Court, couldn't do the case. And they realised then that the case was going to go on to October. We were quite relaxed, as you can imagine, about this. It wasn't something that we were too concerned about. And they panicked. And the issue then was, and the reason their counsel couldn't do it, because you had lots of other cases during the whole of July. We offered a considerable number of dates. I think it was something like 12 different court dates during the whole of July that RQC could do. The net result was that we went back to the court had now ordered it to be heard in July because it is an important case, it involves public money, it involves a matter of very considerable wider importance. So here we are, hopefully we'll be successful. Tickets at the door if you wish. Not pretty cerebral. It'll be interesting to see how they deal with this. So thank you very much indeed, and thank you again to all the team for their support, to me, to David Gerald, and to Nigel Gifford. Thank you.
First of all, let me thank Gerald for that, and I hope you're all energized now. We will have, I see we have some questions from the floor. We have a roving mic, and I will try to remember who's got their hands up. There is a gentleman right here, Ronnie, there's a gentleman right here in the center, and then there's a gentleman there, and there's a woman there as well. So we'll start here. Try and remember, we want to get in as many questions or discussions as possible, so try and keep them really focused. Thank you.
Can I just ask one quick question? Are they allowed to sign an interim contract?
So, are they
allowed to sign an interim contract while this legal challenge takes place?
The answer to that is, I'd love to answer with a definitive answer. How about I don't know? They could do. But remember that, first of all, they've agreed that they will not. The solicitors have said no, they will not sign. It would look pretty poor show if we went to court and they lost the case and they'd signed the contract. I'm not exactly, an interim contract, I'm not quite sure what you mean by that, but actually there is a contract which is on the table. I've got it in boxes and boxes of lever arch files. I can't say I've read it all. But the answer is probably no at this stage. If they did it, it would look pretty critical. Our issue then, of course, is that the case goes against us, and we wanted to take it further for whatever reason. That we could, if we could take it further, then they may decide to say, well, let the devil take the hindmost, enough already.
David is first, then the lady next to him, and then Jack.
Nice to see you again. Former Labour councillor in Barnet, I recommend. 2 points.
That is referring to me, actually. Yeah. That was a Labour councillor in Barnet, but a long time ago.
Correct. Two things. Councillor Thomas, the Conservative Councillor Thomas's comment on the 8,000 signatures on the petition was, it's only an incident, it's only 2%. As far as I know, first of all, there are only 360,000 and growing numbers of residents in Barnet. Secondly, I'm not aware that children are allowed to vote. And thirdly, I'm pretty certain that the turnout is not 100% for elections. So I'm not quite sure what he meant. I don't know if you've got any comment on that. Second point was when Mike Freer, now the MP for Gold Green Finchley, held a budget consultation. He was cabinet member for the budget, and he's joining his period that the Icelandic bank fast took place, when we lost, I think, £500,000. He didn't resign, but other civil servants in Barnet were sacked or retired. I was one of the 8 people who turned up for this consultation, and I heard that 58 people and organisations had sent a letter. Does this amount to a consultation in a borough with about 200,000 adults? It doesn't sound like it to me. When Brian Salinger was the leader of the Conservative group, he received a letter signed by about 12 to 17 people, not 8,000, and as a result of the letter, he spent £600,000 in fees to Price Waterhouse to try and nail the former Labour group leader, Alan Williams, for an executive sale of land. They filed in that. But it seems to me totally amazing that 17 people can generate the expenditure of £600,000, whereas 8,000 signatures, obviously of the wrong political complexion, are ignored. Thank you.
David, thank you very much, and it's good to see you again. The issue about consultation was, remember that that petition did count for something. The evidence that we submitted, which was collated and put together by Barbara and the team, by Maria and the team, did include the stuff about the consultation with Mike Freer, and the fact that actually I thought that was a sham, and the court thought it was a sham. It really wasn't. And indeed, what it says, and I quote again from the judgment, because here the council never set out to consult about his outsourcing programme at all. So what more would you wish? I mean, there was a recognition by the judge that this was really a shimmer, it was a kind of a sop, it was so-called contained in the budget, and it was never really a substantive effort to consult. As to the petition, that did show that there was a really substantive failure in Barnet. To get 7,000 signatures is amazing. These days we get 100,000 across the whole of the UK, we have a debate in the House of Commons.
It was reading the Times when I was speaking.
Okay, Ronnie, give us can I ask you to,
Can I ask you to try and stick to one point so everybody gets a chance to speak? I've got, after you, Jack, Alan, and Poppy's, other people, if you want to raise their hands in the interim, let me know, okay?
Hi. When Maria et al. And the rest of the group win, which they will do, because I'm saying they are going to, what happens in the council? Can they literally reverse it back to how it was?
The answer to that is, that would be, well, first of all, there'd be a serious amount of egg on the face, but they're not. I honestly don't know the answer to that. There may be others in this room. It will be a highly political decision. Maybe Jack sitting behind you maybe have a better idea than I do. But the reality is, if they failed on this outsourcing, which is they've invested so much, it would look pretty poor, would it not? There are elections coming up next year. There may be people who decide that they would want to show their disgust at the way things have gone. But the bigger point is this would send a much bigger message to all the local authorities throughout the country if that was to be lost. It's, how Barnet deals with it, I don't know. We can assess them, we can estimate or guess what they would do. But actually, it will mean that all the local authorities throughout the country have to be very, very careful about consultation. Consultation has to be meaningful, it has to be substantive. You can't just actually just say, look, let's just talk to 2 or 3 people.
But they've already let a lot of people go, and the atmosphere is pretty bad. Have you ever tried phoning them recently?
It is absolutely, it's a real problem, and I've certainly been hearing from other sources about the effect on certainly the unions and various individuals. It is very, very destabilising. I mean, the idea that everything to do with the high percentage of the work of Barnet is going to be outsourced up to Lancashire, to Yorkshire, wherever. People are very worried, and we're in a very difficult economic time, you know that. And I would be very worried, and I'm very grateful that for all the effort that's been put in to try and preserve the tennis. So let's hope that we get a decision and do quickly so we can preserve the jobs and the people are still there.
If they were held to trade unions down,
Ms. Jackson.
I don't actually I wanted to answer the point about linking contract and the point about what happens if Barnet lose. I don't know whether you know that at the cabinet meeting last week, a report was sent through, even at the BAPS notice. It was a report signing a temporary contract with Capital. And it's been exempted from calling, because normally you can call it in. And the reason they've given to sign this temporary contract is that the services and staff have been run down to such an extent that they can't operate properly. I agree with that. Right? Now it's said, but it's temporary to a court case. Now, if Barnet lose the court case, this is mere speculation, based on what I've seen many years ago when they've lost judicial reviews, is that they'll just go out, reconsult properly, and come to the same decision. But in this case, this temporary contract could continue. So in fact, Capital will be running the services during the next consultation process. So I just thought you might want to have some interesting information.
That's very uncomfortable.
Thank you very much, Jack. That's very helpful. I might have seen something about that. I've been away from it till today, so I may not have missed that. I mean, that's quite important to do that. And you're right, I mean, ultimately the challenge has not been a political challenge. The challenge has been actually on a failure to consult. And you're right, it could be. I mean, Barnet had actually said, okay, hands up guys, and decided that when we first contacted them to do the consultation, they could have started it and finished it within the time. But as I said right at the beginning, it has to be meaningful. It can't just be something, just a song. It has to be, people have got to be notified. The Cabinet Office has specific guidance about what is meant by a consultation, and indeed that is part of our case, and that was submitted as quite clearly they've breached that. So they've dug themselves into an interesting hole, or a difficult hole. Well, let's see how we go. I mean, the temporary contract thing is interesting, and I will try and talk to David and Nigel tomorrow about that, because they may have already picked it up. I don't know whether John is here, may want to pass it on to us.
Excuse me for interrupting. Does that temporary mean that it can be extended to temporary?
Well, I haven't seen it, so I don't know. It could be anything.
But that could very happen.
It's possible. It's possible.
Good evening, Gerald. It's nice to see you. I was very comfortable when Maria showed you a very good choice. My concern is not as great as my second concern, but my first concern is what happens when we win. What I mean by this is, does it mean that they have to start again? Does it mean that they have to just, as we mentioned before, just alter the consultation and continue within the law as they see it? What the hell does it mean if they win? If they lose, I suppose I'm more used to losing. But if they lose, I understand that there are different things for you to do. But if they win, I'm almost as concerned about winning as I am about losing.
Yeah, well, the answer to the surcharge doesn't exist anymore, I'm afraid. I mean, if we win, as I understand it, the Tory group on Barnet Council are not actually totally unified on this. So it would be quite interesting to see politically how they deal with this, because it will be a really big knife in the back, so to speak. I mean, with the election coming up, summer's coming, and there's no guarantee, I say this, I mean, we're in court in 2 weeks' time. I wouldn't expect, given the importance of this judgment, that we will immediately get judgment. It's not as if they're going to extemporise. It's possible, but it's unlikely, because they will want to give reasons, and pretty deep reasons. Lord Dyson is a cautious and clever man, but he will think through carefully. The lawyers have legal terms, and lawyers get in theory go on holiday at the end of July. So we won't see that judgment until probably September, October. And then we're then in a situation where we are getting close into Perders, I forget Perders will be sometime in March, April. There's a very, the amount of time to actually do the consultation is reducing enormously. So let's wait and see. But that's if we win. Even if we lose, it's still going to be taken to about October to get the decision. So I may be wrong about that, but this is an important decision. It will have serious impact for judicial review across the whole spectrum, not just this. What is meant by a final decision? When do you make your judicial review? When do you actually say time starts to run? Not just on this, on any other matter.
You mentioned the quality impact assessment in your talk. Now, forgive me if I've got it wrong. I started to be clear about this. My memory is that when the changes took place in the National Health Service, the government suppressed quality impact assessment. So if you're saying that they did a quality impact assessment, but they didn't carry it out thoroughly, I just don't understand how that's part of the case. I don't understand the law, obviously, but if you wouldn't mind explaining to me, that'd be helpful.
I'll try and find, can I just try and answer that? I'll try and find the answer to your question. Could you bear with me a minute?
While he's doing that, if you want to bring the microphone next. I've got a whole bunch of people on this side sitting down.
What? Can I just two things? One is, I've just come back to the NHS case. Are you talking about the risk assessment case? The risk assessment case in the NHS, when the government's exercising veto. I did that case. I was involved in the case, which was what happened was a freedom of information request about my client, the former Secretary of State John Healey, and the application was then agreed. The Information Commissioner said yes, there should be disclosure. The government objected to this, the Department of Health objected, and we had a hearing before what's known as a first-tier tribunal as to whether or not the Information Commissioner was right in reaching his decision on disclosure of the risk assessment. And the risk assessment was about to do with the whole of the changes in the NHS. At that hearing, quite an extraordinary hearing taking place in the old Victoria insurance groups down in near Holborn, the government called no less than the permanent secretary of the Department of Health, Udo O'Brien. But wait for it, they also called Gus O'Donnell, Lord O'Donnell, the cabinet secretary. So we had Lord O'Donnell and Gus O'Brien for 2 days defending the government's position as to why the risk assessment shouldn't be released. It was quite extraordinary. But actually, we won. And the court decided that yes, this was right, this risk assessment should be released. The balance was in the public interest that it should be disclosed, but the cabinet then decided to exercise the veto. It is a shame, and I say it whenever I see my client, it's a great pity that we didn't actually judicially review the cabinet's decision about whether the cabinet, or at least test the water, about whether that veto would be properly used in this case, because we think that the cabinet veto should be used very, 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 very sparingly. And I think only one or two have ever been done. So that was the case of risk assessment. To answer your question about this one, the public sector quality duty here is that their issue was, now can I quote just a bit from this judgment? It says, but this is specifically about the public sector quality duty. But the claimant's case is that the council had inadequate information. The claimant's case, that's Maria, is that the council had inadequate information which to reach the opinion expressed and should have consulted in order properly to inform itself about the potential impact of the changes. What is said is that the council relied on data from a service user satisfaction survey, but that that survey had only been answered by a small and very doubtly representative number of service users, of whom only 16%, some 588 pounds and 88 people, had completed the equality and diversity section of the survey. What is more, that section had not been asked questions about all the protected characteristics, those omitted being gender reassignment, marital status, pregnancy, maternity, religion or belief, and sexual orientation. Now the court went on to say, he said that notwithstanding that, the fact that they had done this consultation, though it was defective, was sufficient. Now, it was the view of our QC that actually that wasn't worth following, wasn't worth proceeding with. It's something that we might revisit, but I think at the moment not. But that's the position, precisely the position. And that's what happened with the risk assessment in the NHS, and that's actually what's happening here. It may not be to your liking, it wasn't to my liking, it certainly wasn't to Maria's liking at the time.
Thank you.
Okay, Patty.
I wanted to make what might appear to be a very obvious, but I think an important and very short point, which is that this case was lost at first instance on a technicality. And you might also say that the whole case is being fought on a technicality, fulfilling or not an obligation in statute. But, what about the substantive issue of selling off the family silver and sacrificing workers' rights and conditions and the quality of the service and losing much of the public accountability for the service? But the consultation issue does go to the heart of the democracy, which should lie at the heart of local government. I mean, it's sort of a scandal that the law needs to tell the council to do what should be second nature, and it's an even bigger scandal that they ignored it.
Can I applaud those sentiments? I mean, remember what's happening in this case. There's a balance now, where a court of appeal have got to decide. You've got a council, which was your point, has breached their consultation, breached their statutory obligation to consult. On the other hand, you've got to say, well, should it have been 2011 or should it have been December 2012? And that's what this court is going to have to grapple with. Because, and that, if they say it's 2012, I won't go into the other technical, because there is a get-out clause for the council or for the local authority potentially, which is suggest they can say, they confirm that there's a breach of consultation, and the council actually have put in what's known as a respondent's notice. They're objecting, they say they consulted. This is really embarrassing because they're going to have to stand up in the Court of Appeal and say they haven't consulted. They're going to get knocked down, and we were wondering whether politically they would opt to make that decision, but they have made that decision to go for it. So it's going to be a bit quite difficult, and they could get quite tough questioning because they want to be seen that they've done it, even though it's inadequate. And this judge has found it inadequate. I'm damn sure that the Court of Appeal will find it inadequate. There's no more evidence that's going to be submitted at this stage. It's on the papers they've already have. So they've got this difficult balancing decision, but there is an inherited jurisdiction, so you could get a situation where the court says, yes, we grant you permission to appeal, yes, we hear judicial review, yes, there has been failure to consult, but there's another section, section 36 of the Supreme Courts Act, which is basically gives them the discretion to say, yes, but the balance of convenience, putting it crudely, is such that so much public money that's been spent on it so far, let it go ahead. So, I mean, that's the inherent jurisdiction of the court. I sincerely hope that that doesn't happen. It's an argument that we've got to protect against. The council is well aware of it, and there's no secret of any members of the council learning now in the village. So if they were, then that argument is certainly there, and their QC is well aware of this. But that's the balance. The balance is between the duty, the statutory duty that they failed, and the question of whether when is delayed. When was that final decision? That is why it's so important. I hope that answers the question. It's very frustrating, believe me, I'm on your team.
Yeah, I'm with Barnet Unison, and we're representing the colleagues in the council who are, as people have said, leaving in their droves, quite literally, because they're working in an atmosphere whereby following the result from that court hearing, an email was sent out by the leader of the council to all staff saying, "Victory! You lost! You know, victory, these services can now go to Capita, which then means victory, you're going to get sacked." You know, and for the council, the leader of the council, for the chief exec not to understand how insensitive that was, really beggars belief, and it's quite worrying actually about who is running the council, that mentality about who's running the council. And I think a lot of staff, those who are still here, still working for the council, are also despairing about what is actually happening now to services run by the council. Because the ethos that they signed up to do a service to the community is slowly being stripped away, or quite rapidly actually being stripped away, and people are just processing, handling things rather than feel that they're providing a service. And that's quite disheartening and dispiriting. And whatever happens to that court case, I think what we need to bear in mind, we have got a lot to do. If it goes in our favour, there'll be a consultation exercise. That means we need people out there campaigning to get the right result on the consultation. If there is no consultation exercise, win or lose, it seems to me Barnet residents have to make choices about who is going to run the council following that decision. And all of that is going to need feet on the streets, people talking. So really it's a plea for everybody here in the room to, no matter what happens, to pick ourselves up and carry on, because I think we've still got a borough to win. The reason why that Barnet Spring demo was called Barnet Spring, although it took place in spring, was it was a calling on, you wouldn't have known it at the day, it was a calling on a referral to the Arab Spring and all those uprisings where people have taken control over their own destiny, and that's what we're appealing to now for people to do. So I really encourage people to get involved and get stuck in. We've got a lot to do.
Thank you very much. That was quite a moving thing you just said there about the email. It's pretty unfortunate. So my question is a general one, which some of you may already know. Really, now that you've seen the document from Capita, you've gone through it, or some of it, exactly what percentage is going to be outsourced? Because I'm hearing lots of different numbers. What is it going to be? Is it 100%? Is it 70%? Is it 50%? What is the number? And if they do outsource, are they going to re-employ some people locally, or is it all going up north to Leeds, etc.? Thank you.
The answer to that question, I don't know the answer, and the bits of the question I do know the answer. I've signed a confidentiality agreement, I'm afraid, and I can't answer it.
They say it's over 17 services.
You couldn't possibly answer.
Sorry, I really couldn't do that. So that would be professional and proper of me. And in fact, all the contracts, all the barristers all signed a confidentiality agreement, and we have to be very cautious about that.
Excuse me, John, you say you can answer that question?
I know a man who does.
Would you come here because the microphone's over there? Just very briefly.
Okay, I'll be very, very brief. My name is John Burgess, I'm Branch Secretary of Barnet Unison, and I've been... I've been involved in this One Barnet programme for 5.5 years when it was Mike Freer's little baby. It was called Future Shape, and then it became Easy Council, and then it became One Barnet. And the consultants took over the council, I'm afraid, taxpayers. The consultants have taken over the council anyway. I get very frustrated because even though I am the trade union leader for Barnet Unison, 3,000 members, I can't speak at these cabinet meetings. I can't speak at the Cabinet Resources Committee. I know so much stuff, and lots of councillors are sitting on these meetings and they don't know half of what's going on. But if I just read out the list of services that I've got. And yeah, so I'm going to, it's an enormous list. Listen.
In the interest of time.
Quickly. Residential supported day living and daycare for adults, council housing, parking, the legal services, audit service, payroll, information technology, human resources, pensions, health and safety, financial, customer services, estates, property services, revenue and benefits, corporate programmes, procurement, electoral registration, trading standards, land charges, planning development, building control, highways network, highways traffic development, highway transport, strategic planning, ending cemetery and crematory, priority intervention team, music service, public health, to name but a few. So when I hear 15%, that is not 15%.
No.
The council is being hollowed out. All that will be left at this moment in time will be children and family social workers, adult social workers, and libraries. Yeah? Your council is being hollowed out.
Don't forget the recycling.
Sorry. Yes. Sorry. I don't know how you should interpret that. The recycling service was provided by May Gurney. That's coming back, and on the 14th of October, that will be in-house with the refuse. But that was always the plan, to bring back the service from the extra, because the contractor wasn't delivering. The future of that service, most of the staff believe that once they've had a year or two of one bar to bed down, surprise, surprise, that will be going out the door with all the rest of the street services. So the idea that they say it's not all about outsourcing, it is about outsourcing. Your council has structurally changed. It is not going to be possible, if you sign these contracts, for you to be able to bring it back. It will cost far too much money. Council tax would have to be 20-30% increase.
Yeah, at the High Court, I got the impression that Judge Underhill kind of had a very sort of don't care attitude towards equality impact assessment. And that's the impression I got from the guy. And lawyers don't use words loosely like people like me. But I mean, the barrister, your barrister for Myria, I mean, when he was summing up on the final day, the thing that I couldn't understand, I couldn't quite make out, is that equality impact assessment is a really important facet of that contract. And the equalities impact assessment wasn't actually completed until December of 2012. So I can't see, first of all, how the contract could be a contract until the equalities impact assessment was actually done. But your guy, David, I think his name was David or whatever his name was, Nigel, yeah, but he turned around and said to the Judge Underhill, he said that you should go along with Birkin. He said you should go along with what he was saying. He said because to do otherwise would be a travesty of Birkin. Now that's a very strong word, travesty. So I can't understand whether this Underhill guy has linked his kind of no interest in qualities impact assessment and his decision not to back Birkin.
I think Birkin was more to do with, not with the equalities impact assessment, Birkin was more to do with the substantive case about consultation. The point you make about the EIA, the impact assessment, was that though that was done in the latter stages of last year, it still was done in sufficient form for us not, there's this kind of much more, less of the duty in a way, though it's in there. It was done by the council, even though I gave you the figures before, it was a joke. But it was done, and we decided that he's made a ruling that he's not going to give it the credence we thought he should have done. But the point about Birkin is what this appeal is really about, is actually the Birkin decision was about a planning decision that relates to a provisional and contingent decision. And there was an appeal saying that you cannot have a judicial review of a provisional contingent decision. And Birkin said you have to have a final decision. And this is what this distinction is, that they're actually going to have this long debate for over a day and a half in a couple of weeks' time about actually what is meant by a final decision. And we maintain, and as you know, because you were there at the back end of the day, at the back, the issue will be that December 2012 was the time when final decision was was made to give the contract to Capita. And at that point, we crystallised the issue that there had been no consultation. We waited, we'd done all we could, written letters, there had been lots of videos of various meetings, and the council had manifested error, and the judge found that. So it comes back to what I was saying before, which is this kind of balancing exercise. So that explains the position as I understand it.
Hello. Mine is a more general question. As the council kind of outsource, there will be cases of negligence, errors and mistakes. Now, directly impacted on that is what's happening with legal aid. And I wanted your expert opinion. What can we do to challenge that? So the government have cut legal aid it's a political move to prevent people from actually bringing more court cases against local authorities and so on. So it directly impacts us. And, I wanted your expert opinion. What can we do to challenge that? What can the Law Society do to challenge that?
Well, the answer is, and I know from my own firm, we do 80% of our work is legal aid work. We have a quite substantial criminal department. And the issue of price competitive tendering, where the government is seeking to reduce the number of criminal firms from 1,600 down to 400 across the whole of the UK, has met with very, very stiff resistance amongst the profession. To get lawyers to demonstrate is more difficult. To get lawyers to demonstrate during the working week is even more difficult. And to actually have a large number of people who turned out outside the Ministry of Justice about a month ago and 2 weeks before that outside of the House of Commons just shows the strength of feeling. But to deal with the judicial review point, that too is under challenge. And if you get a situation where what is known as Treasury Council, Treasury Council are the government lawyers, they're barristers who are private practice in the way, but actually they're known as Treasury Council. And they have recently written a major substantive letter to the government, to Chris Grayson, saying, this is terrible what you're doing. You've got to allow these challenges because otherwise the system will break down. The idea, sometimes government makes mistakes, and judicial review is there to review. Sometimes all it takes, and I've done it, you write a letter before action to the complaint, to the department, whoever it is, say, look, you've done this, you've done that, and the civil servant thinks, yes, you're right. Or the civil servant will say, you get to the next point where you apply for permission, and the judge gives you permission to judicial review, and then they back down. Now, your thrust of your question is, the proposed changes for judicial review are, you are not going to get legal aid if permission is not granted. Now, you think of our case, we could go all the way up with no permission being granted, but heck, we're going to be involved in a major case like this. It's complete nonsense. Now, those cases are a bit of a grey area, we'll have to see. But it's going to be a real fetter on the right of the citizen to have access to justice in the way that it is. And there is a real groundswell. The problem is you can go back to the time, this is becoming a bit political now, but you can go back to the time when Tony Blair decided to make a change from the restructuring of the role of the Lord Chancellor. Because the Lord Chancellor used to be there when you have a lawyer who is in charge of the Minister of Justice in dealing with all the legal affairs of government. That was a movement, quite rightly at the time, for separation of powers. It led to the creation of the Supreme Court. But what it has done is it meant that you don't have a lawyer as of right who is in the Lord Chancellor or the head of the Minister of Justice and actually doesn't understand. Because one of the problems with just simply digressing a bit, it just give you one little case in point. With the criminal lawyers, you have young criminal barristers. They get experience in the magistrates' court, they get experience in the Crown Court, they get experience in the Court of Appeal, and maybe they will start sitting as recorders or assistant judges or whatever it is as things goes on, and ultimately they're the judiciary of the future. At the moment, if we're going to see these cuts in criminal legal aid in the way that's happening, what will then happen is that we'll not get this group of people coming up, and you will get much poorer quality decisions and much poorer quality of judges. It is a real mistake. And you have to be inside the profession a bit, or at least to listen to it. What Chris Grayling has done is very successful in uniting every single branch of the legal profession, from probation service to Treasury solicitors, for the Treasury Council to write in the way they did was quite extraordinary. So hopefully, I've seen today on an email, I don't have time because I was driving here, but I think the consultation period with the price competitive attending the Crown is going to be extended. I don't know whether there's a future judicial review. So it looks as though the government has listened under enormous pressure. So that might be a good thing. It may be that if I'm after the meeting, I'll look at my email, I can tell you what the rest of it says. It might.
Thank you.
Hi, I just wanted to piggyback on what Gerald just articulated very eloquently about the campaign to save legal aid in this country, because it seems to relate incredibly well to what we've been hearing about tonight. Because without legal aid, we wouldn't be able to have Maria bring her judicial review. In the case of Friar Barnet Library, that was a case which the lawyers actually did pro bono, but certainly law firms like Lee Day & Co. cannot operate without the system of legal aid. And I think it's relevant to mention that... I think it's very telling that when the Labour government set up the welfare state in the post-war years, that it saw legal aid and the right of those who cannot afford legal services to access justice. It recognised that legal aid was a fundamental pillar of our welfare state, because there's not much point in having rights and entitlements to welfare if you cannot enforce those rights. And the function that legal aid performs is to give access to justice to the most vulnerable in our society, the disabled, the poor, the marginalised, prisoners. And that's why it's so important. And I was trying to piggyback on what Gerald was saying. What can we all do to help? It's true that in relation to judicial review, the consultation has closed, but there is a petition, there is a national petition at epetitions.direct.gov.uk, that's the government's website. There are over 100,000 signatures already. That's still 100,000 less than the Badger Cull. So I urge you to go on it and add your signature, because that has already triggered an additional debate in Parliament. But in addition, there's also an excellent local petition that I've just been shown, produced by Emily Burns, which is a petition to Mike Freer MP to oppose the changes to legal aid and to get him to have a chat to his friend Chris Grayling and ask him to think again about what will be disastrous changes which will decimate the system, which is not about lining lawyers' pockets, but it's about protecting the most vulnerable in our society and holding the powerful to account.
Hi, I'm Emily Burnham, who's organising the local petition, and thank you very much for announcing it. I just wanted to quickly say that I've given 120 signatures to Mike Freer already, and many of them came from the North Finchley Mosque, who have really been outraged by this. I've also been trying to get signatures from local synagogues and really, obviously, all groups, but I thought, given what happened at the Brahmanese Community Centre, it was really, and the way the rabbis stood up for the Brahmanese community, that would be these changes will, what hasn't been mentioned, they also include a residence test, so you won't get legal aid unless you've been lawfully resident for 12 months. Obviously migrant communities are really at risk, and if they get beaten up by the police or detained in immigration detention indefinitely, they won't have access to the court. So please, there are copies at the back, or if you're interested, please come and sign. It's Mike Freer's constituency members. Thank you.
We're not going to hear from Maria Nash, who has been behind and in front and all the way through with this judicial review.
Hi. Hello.
Come on, Maria.
Here I am.
That's how you go.
Actually, just a plug-in for the police. This is a new initiative for ladies to put on their handbags, so that any unwanted thieves around, you can hear it immediately if somebody's going for your possessions. So I suggest you all get one. I mean, I'm sure that the men can have it as well in their wallets. Wouldn't that be good? You can all become Morrisons.
Hanging on our services.
Yeah, now, this is only the start of our fight. The judicial review is only the start. The hard work comes now, even after the appeal, as we've heard from Helen and points that have been made with Gerald and the lawyers saying how difficult life is going to be for all of us. And the most vulnerable people are going to suffer even more. And unfortunately, as we all get older, we all become more vulnerable. So we as the elderly or the more matured and experienced in this room need to show the young people what needs to be done. We have got the task of taking it out to the community, into the schools, and fight for our rights. We are not here to play games. If we do not want privatization, what should we do? Should we throw out the whole council? Why not? Why don't we become revolutionaries? Throw them all out and put our people in. Why not? Let's think about that. Do something completely different that nobody else has ever done. Maybe that's the way to go, instead of making a start of privatizing and then everybody follows and we all become non-entities and we suffer for the future. So good luck everybody, please go out and fight, and thank you to Gerald and all the fighters behind there in the courts. We look forward to something really important. But bringing in the fact that about disability, I think we need, and I keep on going on with Gerald about this, we need to actually bring the disability issue in the law to say equality is not the only factor. We actually need consultation in a meaningful way. And I think the word consultation should actually disappear, and me coming in. Meaningful engagement, where whatever you're talking about, you engage with the community in the correct way, in whichever way it is, because not everybody can read, not everybody can hear, and not everybody can see. We need to support each other in every way it's possible, and to meaningfully engage with people in the right way. Not say, oh, we've just put it in the newspaper for a week and that's consultation, or put it on the wall somewhere or at a bus stop and say, well, we consulted. Or going into a meeting where it's a room full of people, and they may have objections and they may have ideas, but the outcome is, oh no, we decided what we want to do, and all those people in the meeting agreed. That is falsehood. We should not allow that to happen. And possibly with the legal system behind us, we will win the fight. But we need to get legal aid to be able to do that. So let's fight for everything, and legal aid is a very important thing. Good luck, everybody. See you at the court.